City of Stevens Point Public Protection Committee meeting, recorded October 14, 2019.
Looks like it's about 6:05. We'll call the meeting of the Public Protection Committee to order. I believe Alder Nabel is excused, and we do have a quorum. So we will start with item number 1, an appeal of a service charge for a property maintenance violation. The first address is 2533 Patch Street. Jay Wolf, I believe that is. And the city attorney just let me know that he is unable to attend tonight to speak in his own behalf. I have a question about the fee itself. But is anybody else have any questions first?
If you would remember, this is an item that was discussed a couple of months ago, and this is a rehearing of the postponed action from that
Yep.
meeting.
I had a question about the inspection after initial notice. On this particular invoice for services, Mr. Wolf was charged $100. On the second one, that individual was not. And I wondered why. One is charged $100 and one is not charged, when I would think it would be the same procedure for both. I did leave a message for Mr. Cordes, but he might not have been around today. Okay.
DJ Schneider, Building Inspection Superintendent, Interim Director. So to answer your question, there is an issue with the software that catches that. After seeing this come up, we went back in, we found 6 of them actually that this happened to. So the Dixon Street one should have had that service charge also and did not. So we've identified 6 other ones within that month period where the software, CityView, that we use did not flag us to send the service charge. So now we're gonna have to figure out what we're gonna do with those 6. And go back. It's $600 basically in service fees. They're $100 each, so.
Okay. Thank you. Any question, anybody else have a question? No, you look like, okay. Thank you. I think that, looking at this one, I kind of feel like the way the pictures look about the city property across the street, I kind of can hardly fault Mr. Wolf. I'm inclined to let this one go and uphold his appeal. So I will make a motion to uphold the appeal for 2533 Patch Street.
I would second that.
Okay. We have a motion and a second. Any comments? Sir, you'd like to name and address for the record?
Bob Weir, 727 Second Street, Stevens Point. Excuse me. I was out in the hallway, so I didn't hear the beginning of what
It's okay.
has transpired so far. A couple of comments. Looking at Chapter 21. Okay. Chapter 21 says, "The building inspector shall." The building inspector may. Doesn't say anything about the community improvement officer. Now, I don't know whether he's been deputized as an assistant building inspector or not, but it's just a quick comment. It's a case of the ordinance is not caught up to what has been transpiring, what's been happening. 21.037, no owner or occupant shall suffer and so forth and so on, to have noxious weeds as defined in section, and you have a copy of it, I believe, in your packet. And it lists a list of noxious weeds. At the end of that paragraph, it says, growing in proliferation on a premise. What's growing in proliferation? Have these noxious weeds that are defined in the ordinance been growing on that property? And I might add, excuse me, this change in the weather has gotten me. Previous councils have been told that grass in excess of 7 inches are considered a violation. There is nothing in the ordinance that says anything about grass. A person could have grass to 18 inches and it wouldn't be a violation of the ordinance. Now, this applies also to, I believe, the next appeal that you have on your agenda. So noxious weeds, if I were to have, I don't, but if I had a complete yard full of dandelions, dandelions are not identified as noxious weeds. Okay? If the neighbor to my right and left had beautifully manicured lawns, flower gardens, and so forth, they would be offended because they knew that they would know that my dandelions are going to transplant themselves, and next spring they're going to have a hell of a problem. But right now, again, based on the ordinance, there's nothing that precludes long grass, and there is no identification in the violation report that I saw what noxious weeds are growing in proliferation on the property. Now, I don't know whether the community improvement officer is a botanist or not, but and he's doing a great job. I'm very satisfied with what has been transpiring in the city. But I would encourage the council to take a look at all of the ordinances and read them. And rather than having staff going off on wild goose chases on this project and that project, possibly staff working at revising the ordinances. This applies also to the zoning board of zoning ordinance. Being the chairman of the zoning board of appeals, I know that they're, for the last 5 or 6 years, the zoning code, chapter 23, has been in revision. It's not revised yet. And that might be a problem. The ordinance, again, coming back to chapter 21, the ordinance that you're working with right now, or the chapter you're working right now, says penalties for violation of the ordinance are $100 for each violation, and each day of violation is an extra, each additional day is an additional violation. So if somebody is violating the ordinance for 5 days, it's $500. Rather than $10 for a service, for a notice and whatever it is for cutting the grass. These contractors too, if they are cutting down, if they're cutting down noxious weeds, I doubt very seriously whether they're cleaning their equipment before they go to the next spot. So all they're doing is transporting seeds across the community. And then coming to chapter 21, section 16 on hearings, what you're on right now. 1A says hearings, except as otherwise provided, a person aggrieved by a notice of the building inspector issued in conjunction with alleged violation of provisions and so forth, may accept parking violations, recycling violations, or non-recyclable refuse violations, and snow removal. Last winter, you spent a lot of time on hearing appeals on snow removal, and the ordinance says snow removal is not appealable. Other than that, have a good evening. I'm going to go home and watch a Packer game.
Mr.
Thank you
Does
very
anyone have any
much.
questions for me?
Chairman? I'd like a little clarification
Yeah,
from,
I was looking for the city attorney.
I believe he's in the overflow room. Logan, if you're listening, we could use some advice in here, please.
about a couple of points that he made up that I think are a little bit incorrect, because he said 2103 does not include grass. It does include excessive weeds, grass at a nuisance height.
Yeah.
It is in there. About this $500 for doing something, I think if you don't cut the grass, you're fined, somebody cuts the grass, and you won't get another fine until you let it grow to 7 or 8 inches tall, then you fined again. Okay?
Okay, so there was a lot in there. First of all, the $100 per day, each day, separate violation, that would be if you were issued citations, i.e., here's a forfeiture that we're filing in the municipal court. That's different than what this body hears. This body hears appeals on the service charge that's issued when somebody fails to comply with an order. Now, citations are a tool that's available. We use those. We've issued many of them to various property owners, but usually not in the context of this sort of thing. If you had a situation where it was a rental property or something like that, and it was just, chronically violating these types of property maintenance requirements, then we might look at doing citations, possibly chronic nuisance, that sort of thing. With regards to grass, I mean, we've talked about the grass stuff before. If you guys would like me to mention it over again, I certainly can. But in brief, it's not a noxious weeds violation. It's a violation for having a condition that can create harborage of rodents and such and so forth. Everybody is absolutely correct. There is no height measurement listed in the ordinance. Similarly, though, when you're doing speed enforcement for traffic, most of the time people in a 25 aren't going to get pulled over unless they're doing 37, 38. Maybe pulled over and given a warning at a level a little bit lower than that. But the actual law says you can't violate the speed limit at all. So it's sort of a discretionary level that's in there in order to create some consistency in enforcement, but without enforcing things in a draconian way where it's, okay, we're setting it at 7 inches and we got out the ruler and we found a blade that was over and here you're getting an order. Nobody would want things to be enforced in that way. In fact, I think you'd probably find that in most cases, if grass ends up growing to a height significantly higher than 7 inches before anybody's issued an order. So with regards to the snow removal comments, I'm just going to leave that one alone for now. Might be bad karma to start talking about that. So,
Probably.
so if there's any other questions, I can answer for you guys.
Anybody else? Yes.
Could you talk a little bit about the noxious weeds and the definitions and how the state statutes require us to have a?
Sure. So noxious weeds are actually defined by certain, I mean, here's the list of species, and it's things like garlic mustard, poison ivy, Canadian thistle, et cetera, et cetera, et cetera. There's a lot of things you could add to that list or probably take off the list depending on your opinions about different plants. What's noxious to a farmer might not be a big deal for somebody in their garden. But those are things that are considered actually hazardous to human health or invasive or both.
Thank you. Anybody else have questions for the city attorney?
No, that's very clear.
Okay. We've got a motion to uphold this appeal and a second, so all those in favor vote by saying aye. Aye. Opposed?
No,
Sounds to me like the ayes have it. Was it 3-1?
That's what I heard.
Okay, so that takes us to 2219 and 2221 Dixon Street. Is anyone here from that, representing that address? Another grass, weed, or tree violation? Any
move
questions?
to deny the appeal.
I'm sorry, Mike, move to deny? Okay. Do we have a second? Kathy, seconds? Okay, any comments or questions before we vote?
I will be voting against this motion, as I think one of the things that can get confusing within this, even the letter that's communicated to, is that the three ordinances that are cited are given a title of excessive weed/grass in order to partially justify the violation notice, and that titling that groups the three ordinances together is not actually a part of the ordinances. If you go to the Code of Ordinances, they're numbered, and then the text that follows. So the word grass is really not in the ordinances at all. And I think Attorney Beveridge alluded to that. And the second is, again, this violation, as with the previous one, was not a complaint-driven violation, but rather an observation. And so to use the ordinance that no person may maintain or permit a public nuisance, well, no public has actually complained or brought forth that this is a nuisance. This was the perspective of an individual, of our community director, and I guess I disagree with that, and I think the committee is well aware, as I've continued to articulate that. And then the middle ordinance about the harborage of rodents and insects, the applicant, I believe, said that they haven't noticed any of those harboring, and I really have a question about how that can be reasonably and fairly enforced, because pretty much everyone's lawn harbors insects. And so, here again is a case where our ordinances really, the vagueness make them almost unenforceable.
Actually, I have a question perhaps for the city attorney in terms of, do you have to have a complaint to say that something is a nuisance? I mean,
So I would submit that our staff are still citizens.
Yes.
They work for the city, but they are still citizens. We hire a neighborhood improvement coordinator, whoever that happens to be, to enforce the laws as we have them written. The same would hold true for our police department, as Logan mentioned earlier, building inspections, plumbing, things like that. But your city attorney is here now.
So I believe the question was, do you have to have a complaint in order for something to be determined to be a nuisance?
it says no person may, I think Alder Dalton, you quoted this one, no person may maintain or permit a public nuisance within the city. And there was not a complaint by a citizen. It was an
So-
observation.
That kind of touches upon one of the essential differences between public nuisance and private nuisance. If I have a property that I am cultivating, and you are allowing something on your property to get in there, seeds, chemicals, something like that, and it's harming or destroying my crops, I would have a nuisance action against you. Probably have an action under some sort of statute as well, but I could bring a private nuisance claim against you, i.e. this is a nuisance, it's interfering with my quiet enjoyment. Don't get hung up on the word quiet in there. That's just the hoary old chestnut of English vernacular, the quiet enjoyment of my property. But it's affecting me solely, and by virtue of me owning this particular property. Everybody else, the public, doesn't necessarily affect them. Whereas a public nuisance is something that is considered to affect everybody, whether it's something that's unsightly, something that is an attractive nuisance where it's a dangerous physical situation that would tend to attract curious children or something like that who could get hurt. Or if it's, you're creating a horrible smell or super loud noise, anything like that. So it's a really nuisance is a really general concept, and you can go to court and you can make arguments that something is a nuisance. And it might not be that there's a law that specifically says this exact activity is prohibited, but you would have to argue that this activity constitutes a nuisance and then make references to case law, the definition of nuisance and all that. And then there are things where it's, if you are violating certain statutes, that can be considered what's called per se a nuisance. Like if you're doing this, it's automatically considered a nuisance. So public nuisance is not predicated upon there being a complaint. In fact, it's the kind of thing where all you have to do is be able to make arguments that it exists.
Thank you. Anybody else, any comments? Okay, so we have a motion to deny this. Yes.
I just want to make note that they're really not arguing the fact that the grass is too high here. They're arguing that they didn't get the notice, the first notice, but they got the second notice, so. It's usually one of those things, if you get the second one, the first one probably was mailed to the same address. In this case, both were mailed to the same address, so.
Okay. That's right, I did, particularly was the issue here that, Alder Slawinski.
Alder Slawinski, 6th District. I guess I'm kind of confused here that we just basically granted the appeal for this first, the one at 2533 Patch Street, and reading this, basically the non-compliance notice is identical. So I just am confused on how can we grant the first appeal and deny the second appeal when it's the same non-compliance. I agree that, you know, per these pictures, they should get a violation for this, but again, it just doesn't make sense for it saying exact non-compliance notices and we're going in two different directions, so, thanks.
Good point. Alder Jennings.
So I'll add my 2 cents worth here. I guess I share those same concerns with Alder Slawinski. Also, the appeal is this violation. We are appealing this violation because usually we are sent a notice of violation. In other words, they violate this so often that they expect the city to provide a violation notice. And back to the previous one, this mountain of weeds are pretty obvious violation, and this house in the current one appears to me, or I'll ask the question, is this a rental property? I'd be pretty upset if I were next door to this and it's clearly not being maintained. And I'll just add a third thing, that I'm becoming increasingly uncomfortable with what appears to be us alders litigating on behalf of the complainant. We are not attorneys. And our attorney is still here. I guess I'm just starting to feel really uncomfortable about this. It's happening month after month. We're not attorneys. We're not litigating on behalf of complainants. And so I'm sort of wondering what's going on, and should I feel uncomfortable about this? Or this doesn't feel like business as usual. Something different is going on, and I'm uncomfortable. Thank you.
My understanding is that we're going to revisit an appeals committee in December after the budget process is done. So these would no longer come to this body. And I think it's very appropriate to look at that. Also, perhaps making some of the ordinance definitions more clear. I think it's not a simple cut and dried thing. I think with the first case, the individual was closing on the property. They could very well have missed that first notice. These folks got the second notice, they were mailed to the same place. Makes me wonder, perhaps. But to answer Alder Jennings, I think I tend to agree. I'm very uncomfortable sitting in judgment I don't feel it should be our role necessarily for something like this. So I look forward to that discussion when that comes back in December, and hopefully we can make some positive changes going forward, so.
Just a comment regarding the potential appeals committee. I know people talk about adding layers of government. This is not adding a layer, this is adding an alternative. And one of the things that the city staff had recommended was pulling the alders out of that, to take that issue away from this appeals committee, so they can deal more, like Mr. Ware had been talking about, the letters of the law. And if this council has concerns about the letters of the law, that's in your purview to change the ordinances.
So any other comments from the committee? So we have a motion to deny. So those in favor would vote by saying aye. And those opposed vote by saying no. No. What-
It wasn't apparent, Madam Chair,
Did I
that you were
make-
calling for a vote.
I'm sorry, okay. We have a motion and a second to deny the appeal. So I'll call for the vote. Those in favor of denying the appeal would vote by saying yes or aye.
Aye.
And those opposed vote by saying no? No. So we're tied.
The motion fails. In the event of a tie, it's
So-
not successful, so the motion fails. However, you still have an interesting problem ahead of you, because it's not upheld either. Now, I would submit, and the city attorney is out of the room again. I would submit that in the event of a tie, the motion to deny fails, but because unless someone makes a motion to uphold the appeal, and that is successful, the motion, or the service fee would still stay. Is that correct, Logan? That was a little confusing. The motion was to deny, it ended in a tie, so the motion fails. In the event of a motion to uphold the appeal, what is currently status quo would remain in effect. Is that correct?
Absent action by this body, what the decision of the department would stand.
Okay, so is that clear enough to everybody?
Okay.
Well, what we did last month with the prior case was just postpone until full committee.
You
Or
actually
we
took,
can
you took action
or
already.
took no
You
action.
took action already, though, so I would submit that.
It's different.
It's
yeah.
different than what happened last month.
So if someone wanted
Logan,
to make a
if that's
motion,
incorrect, city attorney, please correct me.
I think at the discretion of the chair, you could entertain a second motion. My expectation is that motion would be one to approve the appeal and likely result in a tie vote as well. But then again, you never know until you have the vote. At which
Okay.
point, if that were to occur, I would think that it certainly could be in order to treat it as having no action be taken and to move on to the next item. And there having been no action to overturn the decision would stand.
My question, though, is, speaking to Alder Dalton's comments, because this committee's already taken action on the item, are they able to still motion to postpone action, even though they took action already?
No.
Last month, in the minutes, as they appear in the agenda, there was a motion to deny that was seconded, and there was a call for the vote, the tied vote. The motion failed. Attorney Beveridge said either the appeal is granted or it is not. He said the third motion would have to be worded significantly different. And then Alder Kneebone moved and Alder Dugan seconded to postpone until next month when there's full membership of the committee.
we could do it.
Let me put it this way. If somebody were to make a motion to postpone this until next month in order to have an odd-numbered quorum, I don't think that the Department of Justice would be dispatched here to throw us in jail.
Well, and you could also result in a tie, which would then result in a failed motion to postpone.
be in like a really bad episode of Star Trek where we're trapped here for eternity.
Yes, time loop.
So taking a cue from last month, I will move to postpone this till November.
I will second.
Okay. Any comments from anybody else on the, okay, so we have a motion to postpone till November, and a second, so we'll call the vote. All those in favor of postponing would vote by saying aye. Aye.
Aye.
Opposed? Would
No.
vote by saying no. So it looks
said
like
no.
we have 3-1 to
Yes.
postpone.
Might I offer that when we do get around to hopefully creating the appeals committee, we might write something into the bylaws for that, establishing that a meeting will not be held with an odd number of members present.
That's very good. I think that would be
Or more
very
important-
wise.
Excuse me,
Good
even
idea.
number.
Yes.
More importantly, you won't postpone action on an item because you have an even number of members.
Always interesting. So, moving on to item number 3, we have, I'm sorry, item number 2. We have a new operators and bartenders licenses. Chief, any issues with any?
Not any of these, no.
Move approval of the list.
Second.
We have a motion to approve and a second. All those in favor vote by saying aye. Aye. Opposed? No? Vote by saying no, I should say. They're approved. Item number 3, change of agent. Ultimate Mart LLC, P.O. Box 30513, Nashville, Tennessee. Jerron Scheider, 200 Cherry Avenue, Marshfield, Wisconsin, agent at Metro Market, 132, 1500 Pinecrest Avenue, replacing Nicole Kearns. And Main Street Taps, 956 Main Street, Stevens Point, Nicholas Halsey, E. 2132 Nelson Road, Wapaka, agent at Main Street Taps, 956 Main Street, replacing Corey L'Esperance. Any issues there, Chief?
No.
Okay. Any
Motion,
questions?
I'd make a motion to approve the change of
Second.
agents.
Have a motion and a second to approve the change of agents. Take the vote. All those in favor vote by saying aye.
Aye.
Opposed? Okay. And number 4, request to hold events or street closings. The Stevens Point Community Turkey Trot, November 28th, 2019. I think if I participated in that, it wouldn't go, I would not be going very far before I'd be stuffed and ready to stick in an oven somewhere. And we have Rick's Run, 8/22/2020. And I believe these both have been done quite a bit, so any issues with either one, Chief?
The only thing with the application process that we do now, unfortunately, there was an oversight in our department where if the applicant does not check off that auxiliary or law enforcement is needed, there are times that we don't get notice and it's not clear here when the committee approves or denies it. So the only thing is we would be following up with the individuals with the turkey trot, merely advising that auxiliary will be needed and provided.
Okay. That's not going to be an issue in preventing the, okay.
No.
I think they can handle that internally.
Yeah, sounds good. Appreciate that, Chief. Comments from the audience? Great events, get involved. Trot or run. So I'd entertain a motion to approve these.
So moved.
Okay. Second by Dugan. Have a motion and a second. All those in favor of the street closings and events, vote by saying aye.
Aye.
Opposed? Sounds good. And we are done at 6:36-ish.